Testing 1 2 3. Testing 1 2 3. This is a test of the Seventh Circuit Court of Appeals. Testing 1 2 3.
Good morning, ladies and gentlemen. Our first case for argument this morning is United States against Bolden. Ms. Masters, perhaps it would be a good idea to wait a moment or two till our high school students have come in. All right, Ms. Masters, let's proceed.
Good morning, and may it please the court. I represent defendant William Beeman, and this morning I'll be addressing the defendant's entitlement to withdraw their pleas due to the multiplicity error raised in the Beeman-Bolden brief and joined by the other two defendants. The defendants entered plea agreements agreeing to the unlawful result of 3 924C convictions, all arising from a shooting on October 4th, 2014. As the government has conceded, that was an error. Today I will briefly discuss why that error was plain and why it affects the defendant's substantial rights and the fairness, integrity, and public reputation of the judiciary. The Ajayi case in this circuit establishes that the entry of multiplicitous convictions is a plain error. And as we discuss at length in our briefs, the Curitin case from 2014, which predates the pleas in this manner by more than 5 years, establishes that the multiplicity error, specifically with regard to 924C charges, arising from one shooting. This error regarding multiplicity...
Ms. Masters, can I clarify something, please, before you go down there? Are you arguing that your clients thought they were facing a 30-year mandatory minimum consecutive sentence based on these 924C pleas, or are you just focusing on the fact that you can't have 3 convictions for the 924C given that it was the same incident?
Both, Your Honor, because what we're arguing is you couldn't have multiple convictions for 924C. They had 7 counts against them, which meant that, in fact, when they entered the plea negotiation process, and we know this throughout the plea process, they believed that they would have faced actually a 70-year mandatory minimum on all 7 of those counts because of the way they would have stacked. That was not explained to them.
But based on, are you arguing that based on the guilty plea that was taken in court, that they thought they were facing these 3 924C convictions to be stacked for sentencing purposes? And if so, can you tell me where in the record you've made that argument?
We're not arguing that they thought that they faced 30 years stacked sentence.
Okay.
We are arguing, though, that the fine provision shows that they believed they were subject to 3 convictions.
Right,
And
not the
that's-
sentencing part of it, just the 3 convictions.
And and we are arguing that misunderstanding of what someone can be convicted of, the number of counts of conviction, is absolutely a fundamental misunderstanding. It is a mutual mistake in this case because the court believed it, the prosecution believed it, the defendants believed it, that it utterly undermined the entire...
What did it affect? Not the amount of time in jail. It appears to have affected the size of the special assessments. That is, they believed, each of them believed, that he was facing $200 more in special assessment than he was in fact facing. Was there any other difference?
Yes, absolutely, Your Honor, because what it affected was their ability to enter a knowing and intelligent plea.
No, tell me concretely what in the real world it affected beside the size of the special assessment.
In the real world,
Yeah.
it affected the size of the assessment, and in our view, the real world encompasses your entitlement to absolutely have a correct understanding of what you can be convicted of throughout the plea
In
negotiation
other words, the answer is
process.
nothing.
Well, and
There is no effect that we can see other than the $200 special assessment. So your client is, in fact, facing a somewhat, by a tiny amount, lower penalty than he thought he was facing. Why would that affect his decision to plead guilty?
because, Your Honor, what it affects is when you don't understand that that all you face when you enter the plea negotiation, when you don't understand that all you face is one conviction out of all of these 7 counts, how could you possibly have been engaged in reasonable, knowing, intelligent plea negotiations about the costs and benefits of the plea you are being offered? And we know that the exchange in a plea agreement, the
But wouldn't it
fundamental
matter
exchange.
what the implications of that plea would be? So
That-
in other words, if the $200 is the only impact of those additional counts, doesn't that go directly to the substantial rights and whether or not they would have pled guilty?
Yes, that goes to the substantial rights. We think in the U.S. versus Cibron case, you can't also underweight the importance of signing an unlawful agreement and agreeing to counts of conviction for which you should not be sentenced. That is a fundamental error in this case. We also think that the fairness and public integrity of the system is really implicated here because they signed a plea waiver. So in addition to agreeing to in addition to never having a proper understanding through the entire process, including the plea colloquy of what counts of conviction they could actually face, they signed a plea waiver. An appeal waiver. They agreed to waive their right to appeal, to even challenge that on appeal. And we think that as well affects a substantial right, the fairness and integrity of the public and the public reputation of the judiciary. I see I'm into my rebuttal, so I'd like to reserve the rest of my time. Thank you.
Certainly, Ms. Masters. Mr. Gallagher.
Nicholas Gallagher of Clement and Murphy for Mr. Burris and Mr. Beecham. May it please the court. The proceedings below resulted, intentionally or otherwise, in the worst kind of bait and switch. Mr. Burris and Mr. Beecham bargained to plead guilty to Vicar assault with a dangerous weapon in return for taking Vicar attempted murder off the table. Then they were sentenced based on the guidelines offense level for Vicar attempted murder anyway, and worst of all, given a sentence 10 years longer than the statutory maximum they could have received had they actually been convicted of Vicar attempted murder. This happened for 2 reasons.
I wish you would use real words.
Yes.
You're trying to pronounce an initialism as if it were a word. I think it would help. We're generalists. Real words help.
Yes, Your Honor, I was trying to avoid the mouthful of violent crimes in aid of racketeering, assault for a dangerous weapon, only because I had tripped over it a few times. That's the statute in question, violent crimes in aid of racketeering. And it has an unusual feature, which is that the attempted murder in aid of racketeering charge has a 10-year statutory maximum, but the assault charge has a 20-year statutory maximum. And the district court disregarded the structure of the statute, the language of the guidelines, and the only extant applicable case law, the Second Circuit's decisions in McCall and Padilla, which explain both. So if Mr. Burris and Mr.
Gallagher,
Beecham...
your client signed very broad appellate waivers.
Yes,
and
Your Honor.
waiving their right to appeal their sentence or the manner in which it was calculated. Why haven't you waived this argument?
We have 3 responses to that, Your Honor. The first is that our clients agreed to be sentenced to and not to appeal their sentence for Vicar assault,
If you could use real words, that would help.
I'm sorry, Your Honor. To plead guilty to and not be sentenced to plead guilty to and not to appeal their sentence for the assault charge, not as to the murder charge. We maintain that there is a substantive as well as a formal guarantee there, and if not, then it wasn't knowing and voluntary. But I think most of all, this is an exceptional case. It's highly unusual. The results were very anomalous and unjust, and it falls, if nothing else, under the doctrine of litos.
We have really limited litos,
I agree with that.
including recently. So how do you get around that high hurdle
If
that
you
we
look
have
at-
said litos imposes?
Yes, Your Honor. I think to begin with, it can't be that litos was the only unique case this court will ever face. So there have to be some that fit within its doctrine, and I think the argument is, does this one? And if you look at Nolf, for instance, which the government cites, it concerns a 2-point enhancement for acceptance of responsibility for a defendant who had pled from 30 years down to 1 year. That's obviously not exceptional. But this case includes not only an 18 years additional in prison, but it got there in a way that contravenes the statutory structure. It would collapse all the subparts of Vicar into one another, and of the violent crimes and aid of racketeering statute into one another, and it would collapse that into the racketeering influence corrupt organization statute. And again, there's this odd fact that if the government had said to them, we really think you committed attempted murder, they would have received 10 less years in return for pleading to the higher charge.
Do you agree that the admissions in the plea agreement were sufficient to find the attempted murder? I understand you disagree with the structure and that the guidelines allow for that, but do you agree that the admissions in the plea agreement were sufficient for the court to find attempted murder as the underlying crime?
We have maintained that our clients never admitted to the requisite mens rea. However, I would say that if the government had chosen to prosecute under either the attempted murder in aid of racketeering statute or the racketeering influence to corrupt organization statute, they would have had a good argument for that, yes. If I may, to turn to your point about the structure of the guidelines. The district court erred fundamentally by overlooking the phrase underlying crime or. Vicar has, beg your pardon, the violent crimes in aid of racketeering statute has...
Just refer to it as the act. It's really very simple.
Yes, Your Honor. In order to be convicted of this crime, you have to satisfy at least two elements, one of which is a violent crime, and the other one of which is a racketeering act, and they cannot be satisfied by the same evidence. And that can be seen from United States versus Brady, which is 67 F. 3rd 1421. That's the Ninth Circuit, but this court has also said that two Vicar statutory elements cannot be collapsed into one. United States versus Rogers.
You did it again.
I know, Your Honor. I'm sorry. I am trying to distinguish.
One of the most important things to understand in arguing to an appellate court is that we're a bunch of generalists, and your home-brewed initialisms and acronyms just bounce off. If you want to make an argument, you need to use real words.
Your Honor, the reason I was trying to avoid the word act there, and I'm sorry for my phrasing, is because I was about to contrast it to the Racketeering Influence of Corrupt Organizations Act, which this was treated just like, but it has a crucial difference. The Racketeering Act can be satisfied by 57 different actions, most of which aren't crimes, unlike in the violent crimes context in which they're all underlying state crimes. So it makes sense that the racketeering guideline speaks only of the underlying racketeering activity and is assessed on pure real conduct principles, whereas the violent crimes guideline speaks of both a violent crime and a racketeering act. The two are to be weighed against one another, as the Sixth Circuit said in its decision in Nicholson, which is the underlying point, I see I'm into my rebuttal time, so I'll stop after this, is that you can't treat the underlying crime as if it were racketeering activity and then use that to free float into different parts of the violent crimes in aid of racketeering statute. I'll reserve the remainder of my time.
Thank you, Mr. Gallagher. Mr. Whalen.
Thank you, Your Honors. May it please the Court. Nathaniel Whalen here on behalf of the United States of America. This Court should affirm defendants' pleas as knowingly and voluntarily entered into, dismiss their sentencing argument pursuant to the appeal waiver, or otherwise affirm. And Judge St. Eve and Judge Easterbrook, I think you hit the nail right on the head on the withdrawal of the plea argument. What's the prejudice? The Supreme Court in Dominguez Benitez said that you have to show prejudice. It's more than just an error. You have to show that but for the error, you would have gone to trial instead of pleading. And the real-world consequence of what happened here is $200 in special assessments. The defendants have never alleged that that $200 is the difference between going to trial on this indictment or pleading. And I think to their credit, they haven't alleged that because it's frankly a little bit far-fetched to argue that they'd be willing to admit to this essentially drive-by shooting, but go to trial over $200.
Mr. Whalen, what's the correct factor that we look at to show that but for the error, they wouldn't have entered this particular guilty plea agreement, or but for the error, they wouldn't have pled guilty at all? What's the correct standard?
I think it's but for the error, they would not have pled guilty to this plea agreement, Your Honor.
They wouldn't have entered this particular plea agreement.
That's my understanding of what the Supreme Court said. That's correct.
And their argument is they wouldn't have pled guilty to 3 crimes when there's only 1 crime there. So how do you respond to that?
Well, excuse me, each case that the prejudice is excuse me, Your Honors. Each case, the prejudice is going to turn on the facts of the given case. And I do think Your Honor's question about the sentencing exposure is a very good one, because had they credibly said that they were facing 30 years consecutive sentence, this is a very different case. But each of their sentencing memos asked for 10 years on the 924C conviction. They understood they were facing 10 years on the 924C convictions. Frankly, their second argument about sentencing today would be moot if they really believed they were facing 30 years, because the guidelines still don't get up to 360 months imprisonment with the relevant conduct analysis. And so they wouldn't care about that because they would have said, well, we're facing 360 no matter what. So in this particular case, Your Honor, frankly, they just haven't shown any prejudice. And I think the Filson case is a pretty good example this court recently handed down, where it's a $200 special assessment. A defendant is probably not going to be able to show prejudice based on $200 in the special assessment. And it's not going to affect the fairness, integrity, and reputation of the judicial proceeding to affirm a conviction where the sentencing is off by $200. Your Honors, the fact that they believe they were subject to 3 convictions as opposed to 1, they haven't shown any tangible effect of that. And yes, the concurrent sentence doctrine might come into play, and the $200 special assessment are applicable, and that's the cases they cite. That keeps their case from being moot, but it doesn't show the prejudice that they have to show. It doesn't show that but for that error, they would have gone to trial. And let me just address the Sura case, and hopefully I'm pronouncing that correctly. The defendants point to that as an argument that the appellate waiver is really the difference, and they're adversely affected because they signed an appellate waiver. Sura dealt with the issue of an appellate waiver and whether the court did not explain the fact that they were waiving their right to appeal. So you look at that error and figure out whether that's the difference between going to trial or not. In Sura, it was the appellate waiver. In this case, it's $200 special assessment. Unless this court has any questions on the withdrawal of plea.
Just a technical
Yes.
question. Has the special assessment been paid?
I don't know the answer to that, Your Honor. I'd be happy to let the court know if you care to know.
I don't think it's vital.
Okay.
All right, please proceed.
Moving on to the sentencing argument, Your Honors, and it seems the defendants are putting their eggs in the Litos basket. I'm very familiar with the facts of Litos, and the defense asked this court to expand Litos to cover this case, just as the defendants in the United States versus Cooper, Oliver, and Ross did. That's a case where the defendants weren't arguing about a lower sentence. They were actually saying we are innocent of 924C convictions. So they asked this court to expand the Litos exceptional miscarriage of justice exception to actual counts of conviction and to saying that we should not be sentenced, convicted, or punished at all for these counts. And this court rightfully said, nope, Litos is a different case. It rightfully refused to expand Litos to the facts of that case. And the fact that the defendants here were facing a higher guideline range is less prejudicial than actual counts of conviction they believed they should never have been sustained. Essentially, the defendant's argument would be if there's a bad error, a really bad error, this court should expand the appellate waiver exception. This court has never adopted that, and that's frankly an unworkable approach as it relates to a term of imprisonment. Your Honors, I'm happy to talk about the actual substance of the guideline dispute at issue. Unless this court has any questions, though, we'd rest on our briefs on that point and ask that you affirm the convictions and sentences.
Thank you, Mr. Whalen.
Thank you, Your Honors.
Ms. Masters, anything further?
Just briefly, Your Honor, SURA isn't about just that the mistake was a plea waiver and whether this court vitiates a plea because the plea has been waived. SURA stands for the principle that one does not, that this court is not engaged in the process of rewriting plea agreements. And we know here that an error has occurred, and we know that the error that occurred here affects a fundamental underpinning of the entire plea process. As the court in Garland ruled, a defendant's right to have basic information, a proper understanding, an accurate understanding of what he can be convicted of is a fundamental basis of the entire plea process. That didn't happen here, and the government has not contended otherwise. And because that didn't happen, and we do point to the plea waiver, because not only did that not happen, not only did they not have a proper understanding of the consequences and of what they could be subject to, they then appealed waived their right to appeal. Those are fundamental errors that require that they be entitled to withdraw their plea. For the reasons in our brief, we ask that that be allowed or alternatively the sentence be corrected. I'm going to cede the remaining time. Thank you.
Thank you, Ms. Masters. Mr. Gallagher.
Thank you, Your Honor. Just one quick point. Judge Easterbrook, I heard you ask earlier about what the real-world consequences were. The real-world consequences for my client in our portion of the argument are clear. If they'd been sentenced as the only existing case law said they should have been, they would have received approximately 12 years in prison. If the government had said to them, we believe that real conduct principles apply here and that you committed attempted murder, they would have taken the higher plea and been sentenced to 20 years in prison. Only through the combination of this uniquely odd statutory structure and the bait and switch, whether intentional or otherwise underlying this, could they attain the 30-year sentence. That is what makes this more than just a bad error, makes it unique and exceptional, and falls under Litos. The court should reach the case, vacate, and remand. Thank you.
Thank you very much. Ms. Masters, Mr. Gallagher, we appreciate your willingness and that of your law firm to accept the appointment and your assistance to the court as well as your client. The case is taken under advisement. We'll hear next in the Firefighters Union against the City of East Chicago.
May it please the court. Sorry about that, Your Honor.
We'll wait for counsel to find a seat at table.
Sorry about that.
Mr. Tolbert.
Good morning, Your Honor. May it please the court, ladies and gentlemen that are present, the students. And my name is Michael Tolbert. I represent the City of East Chicago, and I represent also Mayor Copeland. And we're here today because of an injunction order that was entered on March 28, 2022, that arose out of a scheduling at a fire department in the City of East Chicago. Their original schedule was a 24-48 schedule. The mayor, who was a mayor that was elected in 2010, who ran on saving money and keeping taxpayer dollars down, changed the schedule in order to save money to an 8 to 24-hour schedule.
Well, that's what your client, the mayor, said, but it's not what the district court found.
That's correct, Your
Of
Honor.
course, you need to deal with the district court's findings of fact.
That is correct, Your Honor, and I believe that the briefing and what I'm here to do today is to show that the district court just simply got it wrong. As Your Honor is aware, The abuse of discretion standard is what governs us, and
No, the standard is whether the finding is clearly erroneous.
That is correct, Your Honor, and I believe that the findings were clearly erroneous, and there are a number of facts in the order that I will go through really quickly to show that the findings of fact were clearly erroneous, which led to an abuse of discretion. So the first point I'll make, Your Honor, is the finding that the underlying district court arrived at was that this schedule was put in place for political reasons, and that this was political retaliation because of the firefighters' lobbying efforts with the city council. I found it strange, Your Honor, throughout the 2-day hearing, there was an audio that was also submitted to this court that came up in our preliminary injunction hearing that was a secretly recorded November 2nd, 2019 recording where the firefighter Mata, who was also a plaintiff, who was one of the only testifying firefighters, secretly recorded one Chief Cerna, and then when the hearing came up, they essentially did not want to produce that audio, and there's good reason why. The audio clearly showed over 2 hours and I believe 30 minutes of prodding and leading questions from firefighter Mata, trying to get Chief Cerna to say that the decision to implement the schedule was based on political reasons. You will hear in that 2.5 hours there was no such utterance, there was no such specific statement, but yet and still, Your Honors, the district court somehow in some way in that 2.5 hour audio found that Chief Cerna said that it was payback time, and that was the reason why the schedule was being
Well, the district court didn't quote payback. The district court didn't say that the chief had said payback. He said that based on the evidence, that's essentially what he was saying.
Your Honor, I believe that what the record reflects is that the injunction order said, Chief Cerna said it is pay.
But when the district court was quoting what the chief said, the district court used quotes in the opinion. The district court didn't quote it's payback time.
I agree, Your Honor. The district court did not actually quote that phrase, but they in fact said, based on a finding, that it was payback time, and then they, in my opinion, made a leap in logic by pointing out that there were certain things that were done that were considered political retaliation.
Well, how was it clearly erroneous for the court to find that when the court quoted the chief saying during that meeting, you can call it retaliation, and I'm going to call it, we know what it is you want, what you're going for, so we have to prepare for that. How is that clearly erroneous?
That is clearly erroneous, Your Honor, because you just said it. He said specifically what the reason was for the change, which was preparing for the future, preparing for what the mayor, who was a small town mayor.
It sounds like you're asking us to reweigh the evidence here.
Of course not, Your Honor. I would not be here and drive an hour to do that because I know that would get me nowhere. But what I'm asking you to look at is the clear record and to look at the logic of the district court's whole opinion. I shouldn't say whole opinion, but one of the cruxes of their decision was this audio that the firefighters didn't even want to produce. And then when you listen to the audio doesn't say anything close or remotely close to any claims of political retaliation. In fact, the record shows the opposite. The last comment in that audio was, you have a fundamental right of free speech. That doesn't sound like political retaliation. Also, he said, Chief Cerna in that audio specifically said the reason that he was making the decision to change that schedule was because of the public interest and to save taxpayer dollars. The district court missed that complete 2.5 hour audio and focused on a part which actually doesn't even support the proposition that this decision was political retaliation. And it clearly was erroneous when they did that. And that, I believe, was clear. He talked about he quote, Chief Cerna said this was put in place to protect the public interest. And there's students here, so I won't use colorful language, but he actually cursed and said it was the ordinance that messed all of this up. Didn't say it was the firefighters' lobbying efforts. He said it was the ordinance, which is the whole point of why the district court's decision to say that it was somehow their conduct was clearly erroneous, Your Honor. The next point is this MOU. The court missed the ball on the MOU.
The what? You were here for the last argument.
I was here for the last argument, which was what I'm trying
would you use real English words rather than initialisms that no one but you understands?
I got you, Your Honor. The court messed up bad by saying that this MOU was the whole basis.
Would you use real English words rather than initialisms that no one but you understands?
Okay, Your Honor. I would say the court committed error. They committed error by saying that this MOU was...
No, you're not getting it. MOU is an initialism that
Oh,
nobody
I got you.
but you understands.
I understand, Your
I
Honor.
want you to use real English words.
I understand, Your
And
Honor.
MOU is not
I-
a real English word.
I get it now, Your Honor.
You get it now.
I do.
It's
I
a
do.
long time coming.
Sorry about that. The MOU is a memorandum of understanding is what the term is. And there was a memorandum of understanding that the district court indicated that proved that there was political retaliation because somehow, some way, the mayor implemented the schedule because of a memorandum of understanding that he, one, didn't draft, that it actually came from the firefighters, and that he actually didn't even commit or put any of the terms into it. And I think the other point that I think is crucial about this memorandum of understanding is that on this November 2nd, 2019, during the secret recording, Chief Cerna and Firefighter Mata were talking about the implementation of this memorandum of understanding. The memorandum of understanding was discussed on December 2nd, 2019. So if you look at the logical timeline, the schedule was already about to go into effect. So how can the city or the mayor penalize the firefighters for signing a document that wasn't even in effect when the schedule was implemented? So the timeline, Your Honor, is a problem.
But it was shortly after they declined to sign the memorandum of understanding that the schedule went in effect.
That is correct.
That's
Because
what the district court relied on.
the district court relied, if you look at the record, Your Honor, the
I
district
did.
court...
That's what the district court relied on.
The district court indicated that the memorandum of understanding was the basis behind why the city implemented the 8-hour schedule. The point is that the 8-hour schedule was already on the train tracks and running. And then, if Your Honor, at the record, if you look at the Facebook post from the city of East Chicago's mayor, he specifically says that this MOU was not being implemented for retaliation and was being implemented for efficiency. So the district court completely ignored that.
No, but the district court did not. The district court went on to note that the mayor's own Facebook page said that by not signing that, it left them with, quote, no choice but to move on with the schedule change.
The memorandum of understanding, which was the idea of the union. It was the idea of the union who drafted and put the terms of the MOU, the memorandum of understanding, in place. And once they negotiations broke down, then the original schedule that was already in place, that was about to go in place, was already implemented, Your Honor. So,
Thank you, Mr. Tolbert.
Thank you, Your Honor.
Mr. Tolbert, lawyers sit at counsel table during the argument.
Good morning, and may it please the court. My name is Sarah Fallman, and I represent the International Association of Firefighters, Local 365, as well as 38 current and former firefighters of East Chicago. What we heard here today was the city's request and the mayor's request that this court reweigh the evidence. That is not the role of this court. The firefighters during a 2-day evidentiary hearing, demonstrated that they have a likelihood of success on the merits of their First Amendment claim, that irreparable, real harms would result without an injunction, that the balance of equities tips in their favor, and that the injunction is in the public's interest. And the reason why there is no real factual dispute as to motivation is because Chief Cerna and Mayor Copeland admitted themselves that they instituted this rotating, continuous schedule because of the firefighters' lobbying efforts. Their words are our smoking gun here. So let's hear some of their words.
So suppose that the state of Illinois goes to Congress and lobbies for higher appropriations, and that members of Congress don't like it, and the result is lower appropriations. Does that violate the First Amendment?
I'm not entirely sure the answer to that question, to be frank, Your
I
Honor.
should think the answer is no, unless you're willing to contend that politics itself violates the First Amendment because the losers in politics lose. But that seems to be your argument, that lobbying went on and the losers lost, and therefore politics is unconstitutional.
That is not our argument, and that is not all that went on as politics went on. As the firefighters established at the hearing, they endorsed and campaigned for pro-public safety candidates.
Look, do I have to spell out my hypothetical? Illinois goes to Congress and says, we're Democrats. We Democrats are in favor of bigger spending. We want more money. And Congress, many members of Congress say, we're Republicans. We're in favor of smaller spending. We're actually going to cut the amount of money you get. It doesn't seem to me better or worse for injecting the words Democratic and Republican into it. It might explain why politics comes out as it does. But that seems to me functionally equivalent to the kind of argument you're making, that there was a lobbying input and an outcome made things worse from the perspective of a lobbyist. I'm trying to figure out why that violates the First Amendment. Now, of course, your opponent did you a big favor by not making any argument along these lines. Your opponent just accepted the premise of your suit. But I'm wondering whether the premise of your suit is compatible with the Constitution.
And I would say it is, Your Honor. And that is because opinions about pending legislation, those are matters of protected activity. And in this court's 2009 decision...
So then you have to answer my question by saying, yes, the reduction of Illinois' subsidy from the federal government violates the First Amendment. I'm sure you don't want to answer that yes, because you can see the primrose path you are being led down. But you then need to tell me why your case isn't exactly like my hypothetical.
And I would like to do that, Your Honor. So the First Amendment protects the rights of my clients, both the union and the union members, to petition the government for a redress of their grievances.
True in my hypothetical.
And in this particular instance, the union and the members did just that.
True in my hypothetical. Haven't distinguished it yet.
Correct. And the mayor, and those lobbying efforts failed. The legislation did not pass.
True in my hypothetical.
But what the mayor was worried about, his fear, what he wanted to do was prevent these firefighters from doing it again. He wanted to
True in my hypothetical. They want to cut the money permanently.
Yeah. He wanted to shut down their ability, not just to cut the money, but to lobby on their behalf before City Council for matters that affect both their own employment.
In my hypothetical, the state losing a lot of money will surely discourage them from similar lobbying activities. Yep, that's what happens in politics.
I understand, but in your hypothetical, I would say that is different here because these are individuals who are speaking as private citizens on matters of public concern, and they are being punished for it. And the punishment was real and severe. And in my reading of the case law coming out of this court and others, things like public endorsements of candidates, Those are expressions of views that are protected by the First Amendment. Those are things that my clients did here. The firefighters in the union endorsed the mayor's opponent, and they supported members of the Common Council that they knew would be able to override the mayor's veto on any future salary ordinances. In this activity, lobbying, engaging in the democratic process, these are protected and fundamental First Amendment rights that my clients have.
You're not getting my problem. I mean, it seems to me you have, given your opponent's choice of argument, you have a very easy path here. But the kind of point you're making is true of every political fight where the loser in politics may well be worse off than he was before he began the fight.
But
That's why I think that you're arguing that politics violates the Constitution, and that can't possibly be right.
My response is it's not politics. It's their First Amendment ability to speak.
Losing. Right. Politics is a fight among different perspectives of government. And people who lose in a political race may find themselves worse off. And your argument is that if you engage in politics, which is protected by the First Amendment, and find yourself worse off, your constitutional rights have been violated. And that means politics violates the Constitution. That's what it means.
And if I just may, my argument is actually that you cannot be punished for trying to engage in politics as a private citizen. And the case law is clear on that in the First Amendment. And this is what happened here. My clients...
Actually, I don't think my point is getting across. You're relying on a bunch of cases where a particular person is singled out for poor treatment. What happened in this case was not the lobbyist being singled out for poor treatment. It was a change in policy that affected every firefighter, the mayor's supporters, the mayor's opponents, every firefighter, right? The argument you're making is that what's true for a single individual has to be true at the level of policy choice as well. And that's what's getting me concerned.
And Your Honor, I would say under the Supreme Court's 2011 decision in Borough, which is 564 U.S. 379, it sets forth a semi-answer to your question, where the right of a public employee is a right to participate as a citizen through petitioning activity in the democratic process. And that's what these clients did here. And it wasn't just a policy change. It was a policy change designed to, and which did, cause real harms to each and every one of the firefighters, as well as to the potential public safety of the town.
Not doing anything that tackles my hypothetical. Taking $1 billion away from Illinois harms everyone in the state.
The difference here is that the mayor took something from those firefighters because they decided to engage in political activity. It's not the politics themselves, it's the actions that they took. The speaking at city council meetings, the engaging in conversations with council members to draft this 2019 salary ordinance. It's those actions that the mayor wanted to stop. He wanted to shut it down. His words that he gave at the preliminary injunction hearing demonstrate that he was angry that they took positions opposed to him and that he wanted to punish them. And that punishment had real effect. The union and its members stopped speaking out. They were asked to avoid commenting to newspapers and to the public. It chilled their ability to participate in free speech, which is guaranteed by the United States Constitution.
Was there any economic loss for the firefighters?
There very well may be, but that was not an issue for the preliminary injunction hearing because we were dealing with irreparable harms. There were some firefighters who were forced to expend additional dollars on child care, elderly care, additional transportation costs, loss of second jobs. But the real harms at issue in the preliminary injunction were those that cannot be made whole at a later date. They increased anxiety, they gained weight, they lost the ability to sleep. And that has a real world implication for firefighters who run into burning buildings day in and day out. They need to be at their best. They need to be well rested. They need to be able to be cohesive as a team. And an assistant chief at the hearing found that the schedule prohibited that from happening. Thank you, Your Honors.
Thank you. Case is taken under advisement. Our third case for argument today is Uberlocker against Rock Energy Cooperative. Ms. Lewis.
Good morning, Your Honors. May it please the Court, my name is Julie Lewis. I represent the plaintiff in this matter, Barbara Uberlocker. Your Honors, this is a Rule 56 case. Did the defendants resolve every disputed material fact to merit judgment in their favor? The answer is no. And the reason is that the defendants and the district court are focusing on wrongful viewing under the Stored Communications Act, but in fact the Stored Communications Act has two parts, not one. That wrongful viewing aspect is the first part. The second part is actually accessing a facility and obtaining access to the electronic communication while it's in storage. The defendants do not address that aspect of the statute, and I would argue that the district court did not spend time on that aspect of the statute either. The district court's analysis and opinion notes that Uberlocker contends Rock Energy violated the Stored Communications Act by accessing Angie Schumann's Facebook Messenger conversation with Uberlocker. That's only the first half of the statute. The second half of the statute is that the defendants obtained access to the electronic communication while it was in storage. Therefore, what was reasonable for the plaintiff with respect to filing her Stored Communications Act was to understand the facts underlying both aspects of the Stored Communications Act, both the first element and the second element. The plaintiff...
You don't dispute that inquiry notice is the correct accrual rule here, do you?
No, we don't, Your Honor.
So, under either theory, she saw in January the Facebook posting where she was engaged in communication. Why wouldn't that have put her on notice to do more? She doesn't have to know all the facts. That's not what inquiry notice says. It's would a reasonable person have known that she should have done more.
And what we're arguing here, Your Honor, is that in a wrongful viewing case, in an invasion of privacy case, that would be a correct assumption by both the court and the defendants. However, in this case, the actual violation is the violation of the Stored Communications Act, and she did not have enough facts to, for two reasons. One is she did not have enough...
So your argument is that the Facebook posting could have been stored on the computer?
Our argument and the complaint itself, what she's alleging, is that the defendants violated the Stored Communications Act by signing into her coworker's computer as the coworker, accessing the Facebook server without the plaintiff's authorization, and accessing the plaintiff's messenger conversation while it was in storage. That's our complaint. That's our case. However, the defendants...
So why wouldn't... She didn't know all the facts, but when she saw that they had a Facebook posting of hers, why doesn't that put her on notice of the possibility that this could have happened?
Potentially it does. From a legal standpoint, our argument is that she would not know that they accessed the Facebook communication.
It doesn't matter if she knew it or not. It's would a reasonable person have put on notice that it might have happened, that she should look into it?
From a screen print, Your Honor, we don't believe it's reasonable for her to have known that they accessed the Facebook server. But also, I would say, secondly, it was not reasonable for her because she was under threat of termination. She was terminated that day.
Do you have any law that supports that essential a tolling argument?
No, we're asking the court to recognize that today, that in a subjective individualized analysis of what was reasonable for this particular plaintiff, looking at the Petty decision in the District of Kentucky, as well as the this court's Fujisawa decision. What is reasonable?
But Petty's different because Petty, the issue was there was an underlying dispute as to whether or not they had received the communication in the first place. Here, there's no dispute that your client in January of 2019 saw these postings.
What she saw were paper copies of a screen print. However,
Of the Facebook screen print with the communication.
correct, that's correct, Your Honor. In Petty as well, she saw the cell phone records, she got the subpoena with the
But there was,
attached
the
document.
dispute there was whether or not she had received the underlying screenshot. There was a dispute of fact there that doesn't exist here.
Your Honor, we would argue that there are actually 4 material disputed facts in this case that were noted actually in the defendant's brief on page 6, that Larson had obtained access without her authorization. The defendants do not establish access to what exactly. It is that phrase is submitted to the court as some kind of fact that allows an assumption that she would have known that the Stored Communications Act was violated.
Again, she doesn't have to know. It's put on inquiry notice.
Yes. But what inquiry about what? Inquiry that someone looked at her private message? Yes, she knew that. She absolutely knew that from seeing those screen prints. Inquiry about whether the defendants accessed her Facebook message on the Facebook server while it was in storage? No, there isn't a way she could do that. She wouldn't have known that at that time, and it wasn't reasonable for her to investigate it at that time. I will note 3 other material issues of fact that the defendants note in their brief on page 9. Says Larson's notes say Larson presented the plaintiff with a copy of the conversation found on Angie's computer and explained how we came about it. We absolutely have disputed that throughout the record, and we do today, how the defendants came about that Facebook message. We had no idea then. The plaintiff testified to that in her deposition, and that is a disputed fact that has not been resolved in the defendant's favor. Was she under threat of termination? The defendant's brief on page 10 completely disputes that. That is a very genuine disputed fact here that should be resolved in the plaintiff's favor. She has testified.
But it has to be a material
Yes.
fact. And how if you're asking us to create new law and say it should be told because she was under threat of termination, but if we decline to extend the law to that, what's the materiality of whether or not she was under the threat of termination?
And Your Honor, I would argue that we're actually not asking the court to extend the law as much as to
Create a new tolling rule.
or conduct using the de novo standard an analysis of whether in an individualized subjective way it was reasonable for this plaintiff in her situation to have done an investigation with respect to this law, the Stored Communications Act. Was it reasonable at the time? And it doesn't require new law in our view. There isn't a case that says this particular situation is reasonable.
That sounds
However,
like new law.
Okay. We'll take new law, but be that as it may, it is a subjective analysis, and we would ask the
Ms.
court
Lewis,
to...
are you asking us to adopt some sort of equitable estoppels here?
I beg your pardon, Your Honor.
Are you seeking to have us adopt an equitable estoppel?
No, Your Honor, we have not made that argument in this case. We feel that the duty of inquiry with respect to whether it was reasonable would adequately cover the situation. Finally, Your Honor, under Fujisawa, this court's decision, how easy was it to obtain the necessary proof for a diligent investigation? Fujisawa really could cover this situation, we believe, without having to create new law, and I will reserve my last minute for rebuttal. Thank you.
Certainly, Ms. Lewis. Mr. Myers.
Thank you. May it please the court. My name is Ray Myers. I represent the defendants, Rock Energy Cooperative, and Shane Larson, the CEO. I think the court has, in the questions of counsel, has focused on what is really going on here, is that the plaintiff wishes to establish a new rule that the inquiry notice be extended beyond anything that is reasonable. Judge Connolly addressed that specifically in his opinion, and I won't take time repeating that. But the question presented to Judge Connolly and as supported by the plaintiff in this action is what was reasonable for Ms. Uberlocker to do, given the fact that she was presented with the actual evidence. Unlike as the court, as your honors noted, unlike in Petty, where the question was, what was the plaintiff actually given the opportunity to know what message was intercepted? In this case, yes, the cooperative did have access to the Facebook message that was a private message. That was the question whether that violates the Stored Communication Act was the main issue presented to this court. And there's no dispute that this message was presented to her more than 2 years before she brought this action in the district court here. It's important to note that this action that she did bring was part of a larger piece. She really was bringing an employment action. She originally filed for the EEOC for age discrimination. Got her that case was closed. Got her letter of invite to the district court, which she then used, and then tacked on the Stored Communications Act, and a Wisconsin cause of action for invasion of privacy. She knew from the beginning what had happened. She did not know the actual keystrokes that the cooperative used in obtaining the message. And we did argue, as counsel noted, before Judge Connolly and in the appeal briefs here, that there were that what she learned after the 2 years had expired or shortly thereafter doesn't prove a violation of the Stored Communications Act, in whether or not there's actual storage involved in the method in which the cooperative obtained this message. But that's irrelevant to the statute of limitations question here. The Judge Connolly didn't focus on the other arguments about why the Stored Communications Act really doesn't apply to this. But Ms. Uberlocker did have notice of that this message had been intercepted, and she knew where it came from. It came from the Schumacher computer, the other employee she was in conversation with, and in the appendix that the plaintiff attached to this appeal, in the deposition testimony, she admitted that she understood at the time of this January meeting, more than 2 years before she brought the action, that she's to say on page 38 in the appendix there. So you understood that at that point, at least, or your assumption at that point was that the cooperative had logged into her account, not yours, correct? Correct, because it was on Angie's computer. Angie could have logged into my account from Angie's computer, or excuse me, Angie couldn't have logged into my account from Angie's computer because I had never logged into my account from Angie's computer. She had basic facts and she had an obligation under the statute, which is at risk here, the Stored Communications Act, to make a reasonable inquiry. She relies on two cases to support that. The Petty case, which was a Stored Communications Act, but as the court noted, that was not the issue there was whether there was an issue of fact about whether the employee had the actual message. So Petty doesn't advance her case here. She also looks at the Fujiwasa case, which is from this court, which specifically answers the question. And on page 13, the court specifically said the plaintiff will not be heard to use the ostrich defense here, which is what the court called it. This is if the plaintiff is delaying bringing this action for her personal benefit, and she specifically alleges she was afraid that she was going to be fired, that she wanted continued employment until she believed that was going to end, and then she wants this court to adopt the argument that at that point the statute of limitation kicks in, so that she can control. What she wants this court to do is to establish a new statute of limitations that the plaintiff is in control of. That she is arguing that she didn't have an obligation to make inquiry until it was no longer convenient for her to do so. In this case, it was convenient for her because she worked for 16 months after this message was put out. Only when she believed that she was about to be terminated did she ask for an investigation for further information. So yes, this was available to her. And as the plaintiff has acknowledged, there isn't any case law that supports her argument that she can wait. And in fact, the one case that she cites at Fujiwasa specifically distinguishes waiting for your personal benefit, because that, again, puts the plaintiff in control of what's going on. So this case was ripe for summary judgment because there wasn't an issue about whether she had reasonable knowledge. She had actual knowledge of the message. She had actual knowledge where it came from. She didn't have every keystroke that was used, but that she made, and again, in the appendix submitted by the plaintiff is the memo she drafted asking for an investigation when she thought she was going to be terminated. And at that point, it was too late for her to, she had delayed the 18 months already, but even so, she didn't bring this action until more than 2 years had expired. And unless the court has any further questions, I'm finished.
Thank you, Mr. Myers. Anything further, Ms. Lewis?
Thank you, Your Honors. Just very briefly, I would like to compare and contrast the Petty case and the Davis case. Davis is the case that the district court relied on mainly to, in its judgment and opinion, and the court specifically points out the standard something was afoot. Something was afoot means that reasonable notice inquiry has been activated in a particular case. That's something was afoot is from the Davis case, that terminology, but the district court seemed to focus on that. In our view, Your Honors, something was afoot is a subjective standard that must be measured based on each individual situation. It is not a hard and fast rule that can be applied to every situation without viewing the plaintiff's personal circumstance. When you contrast that with
Thank you, Ms. Lewis.
You're welcome. You're welcome. Thank you, Your Honor.
The case is taken under advisement. We'll hear argument now in the case of Billy against the Village of Channahon. Mr. Fuoco.
Yes. Good morning. May it please the court. May it please Mr. Murphy. I represent the appellants in this case. This case was dismissed incorrectly.
Mr. Fuoco, if you would raise your voice some, that would help.
Oh,
That
I'm sorry.
microphone is for recording. There's very little amplification, and this is a very big room.
Yes, Your Honor, it certainly is.
Thank you.
This case was incorrectly dismissed on a 12B6 motion. This case alleged a constitutional taking in violation of the Fifth Amendment in pleading specific facts that showed plausible taking by authorized government action to develop a floodplain in the backwater of the DuPage River. This occurred in Will County in the village of Channahon. We've identified the individual defendants with responsibility, but the authorized actions.
Mr. Fuoco, concretely, what did the village do that took the property, other than just approve the applications to build in the floodplain?
The applications to build are one of the government authorized actions which directly and proximately caused the
Other
flooding.
than approving the applications is my question. What did they do concretely?
They allowed for the occupancy of houses.
Yeah, look, in Cosby, the taking was flying low airplanes and destroying the value of property. It was something the government did, rather than just permitting people to do what they want. I'm looking for something parallel to Cosby. What did the government do? Did they divert water into this subdivision?
Based upon what they allowed to be built. And again, I rely, as stated in the brief, I rely upon the Blundell rationale that was adopted by the District of Utah.
Look, the District of Utah counts for nothing here. Decisions of the Seventh Circuit and the Supreme Court count for a lot. And what those decisions say is the government has to do something at a minimum, just get you to first base. The government does something that reduces the value of the property. I can't see anything here that the government did other than stop your client and similar people from making what they view in retrospect as a mistake. That is, building in a floodplain. Did the government do anything
Yes.
other than permit your clients to build?
My clients weren't permitted to build, Your Honor. That's the fallacy of this case. My clients all purchased houses either from spec builders
Look,
or...
when I say permit them to build, I mean they and their predecessors in interest. Take the property as it comes, right? So every time I say they, you can hear they and their predecessors in interest. I'm looking for what you think the government did other than just grant permission.
Granting permission is authorized government action.
All right. I hear your answer to my question as nothing at all.
I disagree, Your Honor.
What did it do other than grant permission? And you can't answer that question by saying they granted permission, because the question is, what did they do other than grant permission?
They alleviated the developers and the builders from the obligations that were burdensome, but this village
Sounds like granting permission.
Is there any evidence in the record that the village required the builders to build the basement at the depths that they did? Or was that something that was decided by the builders?
That is such a specific evidentiary fact. What I do know is what the actual depths were. Inferentially, it is reasonable to infer that the village did in fact either require it or knew of it.
And I didn't see anything in the complaint suggesting that the village mandated the builders to build the basements at this certain depth.
I know the as-builts I know they approved the construction, and I know they approved the occupancy, so I'm asking
But
the court.
that's different than mandating it.
But I'm asking the court to reasonably infer, which 12b6 procedure allows, that in fact, the village required that. From the facts pled, that is a reasonable inference, because we have all three pieces of exactly what happened. We don't have the document. That's discovery, and unfortunately, I was precluded from doing that. What you have is a factual record, or what you have are plausible facts that should have been found to state a claim for a Fifth Amendment taking, that should have been allowed to proceed in order to develop a factual record. 12b6 is designed for plausibility review. This was treated almost as if this is a summary judgment analysis. I'll reserve the rest of my time.
Could you come back, please?
Yes, Your Honor.
If the village required the digging of basements, how would that have been done? Or basements of a particular depth?
A plan would be submitted, and Mr. Pankey, who is deceased, who is represented by an administrator, would have said, do it, or I want this modified, or you have to change it. Again, the village is the arbiter of what gets built.
A village acts through ordinances and regulations sometimes. Are you pointing to some particular ordinance or regulation that we should go look at?
Absolutely. And it's all throughout the brief and reply. This is the federal emergency.
I didn't see any ordinance cited in the brief that said that the village mandated that these basements be dug at a certain level. So
Yep.
that's the question. Are you relying on an ordinance from the village or some directive from the village where they said the builder at the time had to build these basements out to a certain depth?
Here is the progression. The village of Channahon is...
I'm sorry, I don't mean to interrupt, but is there a particular ordinance you're relying on? I know you're saying draw inferences from this and that, but the question was more specific than that.
And I will answer your question. The criteria for land management is an obligation of a participating community in the flood insurance program. Ordinance 703 in section 200 confirmed that the village was bound by all FEMA regulations pertaining to land management criteria, and that is what they were obligated to do. That is what action they had to take to make sure that these houses were built to be reasonably safe from flooding. And that those actions were not taken.
I know you're completely losing me, and perhaps you are, Judge St. Eve, as well. We are looking for things that the village required people to do, as opposed to things the village permitted people to do. And you're just not drawing that distinction. You're not helping us, therefore. Is there something you can tell us about what and how the village required your clients and their predecessors in interest to do?
It's the construction planning process. Somebody proposes something. The village plan reviewer has the total and complete power to say, this is what you do.
Well, no, they don't.
If it's confirmed in the plan, then it's okay.
They can do that, and then they're subject, they're subject.
Or a modification of a plan.
But they didn't. They approved the things submitted to them.
Your Honor, that's evidentiary. That takes discovery to
No,
get...
if you think you can file a lawsuit like this without even alleging that the village demanded changes in the plans, I think you're pretty much mistaken.
The only way to get construction plans is by subpoena. I don't have the power to subpoena. I have to create a record.
You represent property owners who are in contractual relations with their predecessors in interest. Have you tried to get any of these documents from them?
Construction plan documents would not be with them because these are spec builders. These are people long in the past And those documents would be possessed only by the village of Channahon. That's a record set of as-built construction, and it's a construction plan folder or electronic stored documents on fiche that I can only get by subpoena. I cannot answer your questions because I haven't been allowed to do discovery.
This sounds like a Rule 11 problem. Anyway, your time has expired, counsel. Mr. Murphy.
Good morning, Your Honors. Jim Murphy on behalf of the Village of Channahon and the individual Channahon defendants. I think the courts have pointed out, and through the questions, some of the issues that really doom this case. What plaintiffs are asking you to come up with is a taking that has never been allowed by any court that we know of, and that is a taking based on flooding without any governmental action that actually increased the amount of water onto plaintiff's property. The complaint is clear in this case that didn't happen. The complaint specifically alleges that the reason for the flooding is because of the depths of the basements that were built. That is plain and simple. There is nothing in Channahon or in the complaint that alleges that the basements were required to be built at the depths they did. In fact, it's a reasonable inference that they were built at the depths that were requested by the spec builders, the plaintiff's predecessors in interest.
Well, I have the same question for you that Judge St. Eve asked to Mr. Fuoka, which is there anything in the ordinances or zoning regulations that speaks to the mandatory depth of basements?
I don't believe so. It's certainly not alleged in the complaint, just knowing generally.
Look, one does not allege law in a complaint.
No, I understand.
You find out what's in the ordinances by looking at the ordinances.
There would be nothing that I am aware of, and from general construction, you could build it on slab, you could build it with a crawl space. You don't even have to build it with a basement. So in that sense, the answer is certainly no. The only other thing that I would point out in this case that the district court did not get to is we are dealing with a case that goes back over 26 years before the case was filed. The plaintiff actually demanded in 2009 that their house be bought out. That's well before it was filed. We have brought up statute of repose that we think the federal courts are...
Isn't there a question of fact, though, on the statute of limitations as to when they requested a buyout? That's not something that the court could have decided at the 12B6, is it?
In terms of, it's pled that they asked for a buyout.
In 2009?
In 2009.
That they pled that?
They pled
Okay.
that, yes. Now, that only goes to Billy, defendant, I'm not sure about, plaintiff, I'm not sure about other plaintiffs. But it certainly indicates the other plaintiffs would have known with the same information that Billy did. And with regard to the statute of repose, that's a 10-year that we think should be engrafted onto the 2-year statute of limitations for 1983 purposes, because the courts have said when you borrow the state statute for personal injury, you need to borrow the other statutes that go along with it. And under the Illinois Supreme Court, they have found that the statute of repose gets grafted onto that and it prevails. And that 10 years ran from 96 to 2006 was when the statute of repose ended. So even if you were to somehow find that there's a cause of action, we'd ask you to go back and specifically take a look at that and also our other arguments. But really the issue here is, has there been a taking? And as your questions have seemed to indicate, and we believe the district court was absolutely correct that there has not been a taking in this case. So I have nothing else unless you have questions for me. No? Thank you, Your Honors.
Thank you very much. The case is taken under advisement. King against Dart is our fifth case for argument today. Mr. Morrissey.
Good morning, and may it please the court. My name is Patrick Morrissey, and I am one of the attorneys for the plaintiff appellant, Baron King. On March 29, 2019, a fight erupted at the Cook County Jail when the assigned tier officer, defendant Zuhl, left 39 inmates unsupervised in the day room. About 7 minutes later, the fight continued when an inmate threw boiling water on Mr. King. When the assigned correctional officer returned about 30 minutes later, Mr. King requested medical attention. Mr. King waited until the following day to receive treatment. On April 2nd, 2019, Mr. King filed a grievance complaining about the attack in his living room. The same day he filed this grievance, he received a response by the sheriff's social worker directing him to the Office of Professional Review and the divisional superintendent, who were going to undertake a review and/or investigation. The same day Mr. King filed this grievance, he also filed a second grievance where he alleged that for about 24 hours he was denied necessary medical attention. Unlike the grievance that he filed about the failure to protect, this grievance was referred by the social workers to a department, and he received a response. Unsatisfied with this response, he filed an appeal, again explaining that for 24 hours after this attack, he did not receive medical attention.
Mr. Morrissey, I want to focus on the grievance with respect to the delayed medical care, please.
Yes.
What in that grievance put the jail on notice that you were pursuing a claim against Officer Zuhl as opposed to the medical professionals?
Yes, Your Honor. The grievance under the section required name and identifying information. He identified the Division 9 CCDOC staff. And granted...
But he only identified them in connection with them taking Division 9 staff taking him to the hospital. There wasn't anything else about the Division 9 staff.
But Your Honor, reading the context of the grievance, he talks about how for 24 hours he was delayed medical attention.
But again, the whole point of the grievance procedure is to put the jail on notice so they can address it. And he certainly filed the grievance here. But the question is the grievance and putting the jail on notice about Officer Zuhl. And even the reference to the Division 9 staff talks about them taking him to the hospital on March 30th when Officer Zuhl wasn't even on duty that day.
That's correct, Your Honor. And this is in the context of an inmate who was seriously injured. In a few days after this incident, he is trying to gather and put together a grievance, and he did not know who the officer was. And you can identify that, Your Honor, because the first grievance that he filed about the failure to protect allegation, he doesn't even identify Officer Zuhl in that grievance either. But in that issue, Your Honor, there's no confusion or difficulty by the jail officials understanding what happened. I think these two grievances, Your Honor, have to be read in conjunction with each other because he's doing his best to follow the jail's procedures because the jail requires inmates to only identify one problem, incident, or event per grievance. And I believe reading the two grievances, Your Honor, together, it shows that Mr. King is doing his very best in a very difficult situation to provide the best notice he can to the jail officials about what he's complaining of. And so I agree, Your Honor, he doesn't identify the specific officer in that grievance, but I believe the jail officials have fair notice about what is going on, particularly when reading these two grievances together. And, Your Honor, the district court dismissed this case for failure to exhaust the available administrative remedies as required by the Prison Litigation Reform Act. And the district court erred because the evidence shows that the procedure that was in place when a grievance is referred to the Office of Professional Review and the divisional superintendent, it was unclear. And the district court erred dismissing the delayed medical attention grievance because I believe the plaintiff did everything he could do to raise this matter with the jail officials. Turning to the failure to protect grievance, Your Honor, it is undisputed that the jail's social workers are only there to process grievances. And when Mr. King filed this grievance, he was told that these two entities, the divisional superintendent and the Office of Professional Review, were going to undertake some type of investigation. The evidence shows even the jail officials have confusion over what happens when these grievances are referred to these two entities. The social worker who addressed the failure to protect grievance said that she would assume that the OPR is part of the administrative remedies at the Cook County Jail. The other issue, the divisional superintendent, the same social worker said she would imagine that the divisional superintendent would undertake some type of investigation. Turning to another issue, the director of the grievance system, John Mueller, I believe he said he wasn't even sure why this grievance was given to the divisional superintendent for review and or investigation. So under these circumstances, the procedure available for a person like Mr. King in the spring of 2019 was unclear. And to provide some context, in 2020, there seems to have been a change in the procedure at the Cook County Jail. This pre-printed form that Mr. King was given was changed to include a disclaimer that directs, it calls this process the immediate grievance response, and it provides some direction to inmates about what to do when they file a grievance and it's referred to the Office of Professional Review and the divisional superintendent. So that evidence shows that the grievance system was not clear in 2019.
Have they amended the inmate handbook? Do you know?
Your Honor, I can't answer that question. I'm not sure. I'm sorry, Your Honor. But the evidence shows that the system was unclear when Mr. King filed his grievance. And I would ask that this court reverse the decision of the district court and remand for further proceedings. Thank you.
Thank you, Mr. Morrissey. Mr. Brennan.
May it please the court. This court should affirm the district court's order for two reasons. First, plaintiff failed to exhaust his administrative remedies relating to his failure to protect claims because he did not appeal the response he received to his first grievance as required by the grievance procedures. Second, plaintiff failed to exhaust administrative remedies relating to his medical care claim because he did not identify or describe any wrongdoing by Officer Sewell and therefore did not place the jail on notice.
Which part of the handbook or form requires the inmate to identify a particular guard by name?
That information is included on the grievance form.
Now, which part requires the inmate to identify a guard by name? I'm asking this because it seems to say you must describe the incident, right? You can identify somebody by name if you want, but the question I'm asking is, what part requires the naming?
The grievance response form, it has required name or identifiers of accused. Under the Prison Litigation Reform Act, a detainee must comply with the rules as prescribed by the jail's grievance procedures to properly exhaust
Mr.
administrative...
Branham, let's go to the failure to protect grievance. When he submitted that, he got a response that told him his allegations had been forwarded to the offices of professional review and divisional superintendent for review and/or investigation. What exactly is he supposed to appeal from when he gets that?
In the evidence in the record in this case, the testimony of Director John Mueller on page 106, he testified that plaintiff could appeal, that he did not want the Office of Professional Review or the super.
Isn't that something that's mandated by the jail when they get this type of misconduct complaint, that it has to go to the Office of Professional Review or Director of Superintendent?
Yes, Your Honor, the Office of...
So if he appeals, the whole point of appealing is supposed to put the jail on notice so that the jail can address it in the first instance. If he appeals something that has a mandatory jail procedure that it has to go to this office for review, what possible good does that do?
Well, first, plaintiff is required to exhaust the process, the administrative remedies process.
What possible good could it do to require the plaintiff to appeal the fact that it was sent to the Office of Professional Review? He doesn't have an outcome.
It would open the door to have this grievance reviewed by an additional layer.
Where is he informed of that?
In both the inmate handbook and on the grievance form itself.
Where is he informed in the inmate handbook that if you appeal a referral to the offices of professional review and divisional superintendent, that you could have a second layer of review? I didn't see that anywhere in the handbook.
Correct, Your Honor. That level of specificity is not included in the handbook, but what the handbook does say is that in all circumstances, the inmate must appeal a response to his grievance to exhaust his administrative
But this
remedies.
is not a merits response. This is more, we're sending this somewhere else for further review. Let's carry it out further. So he appeals the review. They say tough, it's going to go to the review. Then does he bring a claim saying, I'm suing for sending this to the offices of professional review? That makes no sense.
Exhaustion must be complete from start to finish. This court
It also has to be understandable for there to be exhaustion available. And I read these forms, and they're a bit circular, and our district courts are a little bit all over the board on how they read the forms. I think that's a bit telling.
So those district courts that plaintiff or appellant cited in his brief, they are not in disagreement. Those courts were actually interpreting an earlier version of the jail's grievance procedures. And in those earlier versions of the procedures, it told detainees that they would be informed if their grievance was sustained or not sustained. And until they received that information regarding their grievance.
But what those district court, the district court opinions speak for themselves. We don't have to go down that route for purposes here. I don't understand from the form that was sent to him in response to his grievance that this was going to the Office of Professional Review, what he's supposed to do, especially when that same form says you may follow up with the offices of professional review by contacting their office directly. That suggests permissive, not mandatory.
Either way, that was the response to his grievance that he received.
That's my point. How is, and we take this from what an average person in jail would understand. So he's told, not the merits, but he's told, we're sending this someplace for review, which arguably would be a good sign that it's going to get a hard look at by the Office of Professional Review. And then he's told, you may follow up with the office. Oh, but you have to appeal within 15 days. It's very circular, and it doesn't make a lot of sense to me. I'm not sure how it would to a prisoner.
His response to his grievance is, we are taking your allegations and we are sending them to the Office of Professional Review. Plaintiff could have been dissatisfied with that response and said, you know what, an investigation is not going to help me. How is this investigation going to give me anything that I want? I want to file a lawsuit. I want money damages. So I'm appealing this response so I can exhaust my remedies and file a federal lawsuit.
What's the role of the divisional superintendent? the record seems silent on that, and this form is telling him that this is going to the divisional superintendent as well.
That information, those allegations were referred to both Office of Professional Review and the divisional superintendent. Those
And
processes.
what's the divisional superintendent's role? Is there anything in the record about that?
I believe the superintendent, Cian Cirillo, testified that he is given that information so that he can take any action with his employees if he deems it necessary. That information is not meant to convey or be in relation to anything that plaintiff is grieving. Those two processes are separate. The internal review process is so that this divisional superintendent can take action with his employees as he sees fit. It's not to get back to the detainee to inform them of what we're doing with your allegations.
Is there anything in the inmate handbook that identifies what an inmate is supposed to do if they get a response that their claim is being sent to the Office of Professional Review, specifically?
No, and the reason that it doesn't is because it's not part of the grievance procedure. There's no reason to tell the detainee that some other separate process.
So it's not part of the grievance procedure, but you have to appeal it? The decision to go there? Again, we're back to the circular.
So the detainee has to appeal the response, not the outcome of the internal affairs investigation. The response that he received to his grievance was, we are taking your allegations and we're sending them somewhere else. That's the response to his grievance. He had to appeal that in all circumstances if he wanted to exhaust his administrative remedies to file a federal lawsuit.
And what would the appeal have said? Don't send my grievance to the Office of Professional Review?
The supervisor who responded to his grievance testified that he could have received the response, sat on it for 15 days and said, you know what, I'm not happy. Nobody's come to talk to me. I want to appeal. And in that case, if he would have appealed within the 15...
But that's a different appeal. That's saying you're not moving fast enough. That's not saying I don't want this to go for review.
The detainee has to exhaust the process from start to finish. They don't have to exhaust a remedy. It's the process that they have to exhaust and get to the end.
I don't think that's a kind of argument you want to make to a court. Joseph K. was told that he had to exhaust a process. You remember who he is, right?
Respectfully, no, Your Honor.
He's the protagonist in Kafka's The Trial.
The Prison Litigation Reform Act does not identify the rules that a detainee must follow to exhaust remedies. Those rules are prescribed by the jail. And in this case, the Cook County Department of Corrections has developed a grievance procedures that they've decided is sufficient to alert them of the notice, to give them notice of the allegations in a grievance. And in this case, the grievance procedures require...
But an ordinary prisoner has to know that from what he's told and provided by the jail. That's the challenge.
And plaintiff was given that notice both in the inmate handbook and on the grievance response form itself that says you must appeal the response you received in all circumstances to exhaust your administrative remedies. For these reasons, I ask that you affirm the district court's order. Thank you.
Thank you, counsel. Anything further, Mr. Morrissey?
No, Your Honor, unless the panel has any additional questions.
Seeing none, thank you very much. The case is taken under advisement. Our final case for argument this morning is Porosh against Garland. We have Mr. Cochran. All right. Looks like we do, though oddly vertical. Ms. Schumer.
Thank you, Your Honor. May I start? May it please the court, my name is Marwa Jamani. I represent petitioner Mr. Alamin Porosh. I would like to...
Could you please raise your voice? As I said to one of your predecessors, that microphone doesn't amplify, it records.
Understood,
And
Your
this
Honor.
is a big room.
Understood, Your Honor. May it please the court, my name is Marwa Jamani. I represent petitioner Mr. Alamin Porosh. I would respectfully ask to reserve 2 minutes for rebuttal, Your Honor. Mr. Porosh is 25 years old, native and citizen of Bangladesh, who has been in detention with immigration ever since he entered the United States. We would just
If you can't raise your voice, perhaps you could speak more slowly.
understood, Your Honor. We would respectfully ask this court to remand the case and grant the petition for review on the ground that substantial evidence on the record compels an alternate finding, Your Honor. The immigration judge decision, as supplemented by the Board of Immigration of Appeal, erroneously questioned Mr. Porosh's credibility and faulted him based on his speculation and unsupported personal opinion, and even faulted him for not providing additional corroborative evidence in support of his claim. For example, Your Honor, the immigration judge used Mr. Porosh's young age to be political activist, about his political activities. Second, about his political activities in Bangladesh. Third, when the immigration judge mischaracterized the country condition evidence and did not take the totality of the country condition evidence and faulted Mr. Porosh's credibility. And fourth, when the immigration judge did not articulate in his decision about what additional corroborative evidence that Mr. Porosh should have provided, neither give him the opportunity to explain why these evidence are not reasonably obtainable. And turning to my first point, Your Honor, the immigration judge specifically stated that erroneously based on his personal opinion, that how it's difficult for this court to believe that Mr. Porosh, due to his young age, was able to recruit members to his party to the extent that pose a threat to the opposing political party. However, the immigration judge here, Your Honor, did not point out to anything in the record or country condition evidence or case law where stated young Bengali individuals did not participate in political activities. And second, Your Honor, the immigration judge stated that Mr. Porosh was vague about his job duties, while Mr. Porosh specifically testified about his activities with his political party. He testified that he was an active participant in political meetings for his party. He was instrumental in recruiting members to his party, and he would provide community activism as part of his political activism, and he was able to meet with members of the public and educate them and advocate for his party. The immigration judge did not follow up with the questions or what additional activities that Mr. Porosh could have done in order to consider him that he...
But there's no obligation for the immigration judge to do that, is there? The judge doesn't have to identify additional evidence that the petitioner could have come forward.
Your Honor, we are talking about additional activities. He faulted Mr. Porosh based on his own speculation, and he was vague about his duties. However, he never pointed out he stated he was not clear about how many members he recruited. He could have asked Mr. Porosh about these additional questions. However, the immigration judge never did and speculated that he was vague about what he did in Bangladesh. And third, most important point, Your Honor, that the immigration judge clearly mischaracterized the country condition evidence submitted to the record, Your Honor. The immigration judge solely focused on acts that occurred in 1970, decades before Mr. Porosh was even born, and did not take into the consideration the current country condition evidence, where specifically stated that the U.S. Department of State did not designate Jama'at to be a terrorist organization. Second, Your Honor, the immigration judge also mischaracterized the country condition evidence when he focused on the inception of Jama'at in 1940, Your Honor. However, he did not take into consideration the current country condition evidence, and I am reflecting to page 316 on the record, where it states that Jama'at advocates for a stronger societal and political foundation in Bangladesh. And third, Your Honor, the immigration judge misstated that only leaders of Jama'ah were persecuted in Bangladesh. However, Your Honor, the country condition evidence, and I'm reflecting to page 341, specifically stated the U.S. Department of State Human Rights Bangladesh 2020 that both leaders and members of Jama'ah were persecuted, Your Honor. Your Honor, the immigration judge and the Board of Immigration of Appeal are expert agency. They are supposed to be special on the field. They are not supposed to solely focus on things that happened decades before Mr. Porosh was even born, and not even take into totality what the current country condition evidence is saying, along with Mr. Porosh's testimonial evidence and the corroborative evidence, Your Honor, submitted to the record. Clearly, Mr. Porosh's inception of Jama'ah, he testified he joined Jama'ah because what attracted him is what he witnessed on the local level, what he witnessed members were doing at the time he joined. They were responding to natural disaster, providing food, water, and that's what attracted him, not what had happened, Your Honor, like decades before he was even born. Clearly, the immigration judge clearly arrayed on this specific point. And Your Honor, the most important point also, corroboration. The immigration judge did not take into consideration this court ruling, Your Honor, in Rafael V. McCaskey, where this court specifically requested the immigration judge to first articulate what additional corroborative evidence that he would have expected petitioner to provide, and second, give the petitioner an opportunity to explain why these evidence were not reasonably obtainable. And the immigration judge in this case failed to do so, Your Honor. And even, Your Honor, the BIA tried to cover it up or sweep it under the rug by saying the immigration judge reviewed them, but they are not corroborative. But the immigration judge did not go through these two steps analysis, articulate what additional evidence, and give Mr. Porosh the opportunity to explain why they aren't reasonably obtainable, Your Honor. And also, the immigration judge faulted Mr. Porosh because he was reading from materials while, Your Honor, due to the hearing was by televideo, and Mr. Porosh was in detention and under the supervision of the guards. Neither the guards nor the immigration judge instructed him that he could not have materials. And that was during the cross-examination, not during direct examination, as the immigration judge misstated, Your Honor. And we respectfully ask this court to remand the case and grant the petition of review because substantial evidence in the record compels an alternate finding, Your Honor. We'd like to reserve the time.
Thank you, counsel. Mr. Cochran.
May it please the court. Todd Cochran on behalf of the Attorney General. The court has just heard Ms. Juma try to convince it of a different way of looking at the agency's adverse credibility determination in hopes that the court will overturn that decision. But as the court is aware, the standard of review of the agency's findings of fact, including adverse credibility determinations, is substantial evidence. In order for Mr. Porosh to convince this court that the agency's findings were not based on substantial evidence, he has to show more than a plausible alternative theory to warrant reversal. Pursuant to 8 U.S.C. 1252 B4B, he must show the evidence of record compels reversal. He cannot do so. The agency relied upon a number of reasons to make that finding. First, as mentioned in the answering brief, Mr. Porosh waived the argument about contradictions between his testimony and documentary evidence. And alternatively, he testified numerous times that he joined Jamaat because it was pro-democracy. That can be found at AR 145 to 46, 152 to 53, and 212. Yet his own evidence stated that the party considered democracy to be forbidden. That's at AR 308 to 09. Second, despite testifying that he joined Jamaat in 2012 and worked as a recruiter for the party, The agency determined it was implausible that Mr. Porosh would be unaware of a number of significant events involving Jamaat, even after he joined, contrary to what Ms. Juma just told you, including the war crimes committed in 1970, protest riots in 2013 in response to Jamaat leaders being put on trial for those crimes, and the executions of prominent Jamaat leaders in 2013 to 2015. That can be found at AR 147 to 48, 307, and 314. Third, Mr. Porosh attempted to read a prepared statement at the outset of redirect examination in his continued hearing, and he provided evasive and confusing responses about a doctor's note authored in 2021 purporting to describe treatment rendered to him in 2014. That can be found at AR 204 to 05 and 161 to 69. And fourth, he failed to sufficiently corroborate his not credible testimony because he submitted 2 letters from his parents that were identical and omitted key facts. For example, they did not even mention that Mr. Porosh was a member of Jamaat. They did not describe when and how he was allegedly harmed. And he also submitted letters from his uncle and his cousin that were similarly vague and unspecific. Those can be found at AR 258 to 61 and 290 to 93 and 298. Because substantial evidence supports the agency's conclusions and Mr. Porosh has not presented any arguments compelling the court to reverse that determination, the court should deny the petition for review. Subject to the court's questions, the respondent rests on the answering brief.
Looks like we have no further questions. Anything further,
Okay.
Counsel?
Thank you, Your Honor.
Your Honor, responding, I addressed the 9040 acts. These, Mr. Porosh should not be faulted for these acts that occurred, Your Honor, decades before he was even born, and that was the inception. Now, the current country condition in page administrative record 316 reflects that now Jamaat are advocating for a strong societal and political foundation in Bangladesh. When it talks about, like, you should have known about 2013 riots, Your Honor, the immigration judge, based on his unsupported personal opinion, assumed that he should have known about these. However, he never asked where these riots took place or whether these riots took place at the area where Mr. Porosh lived, and he just assumed he should have known about these acts, speculated, but never follow up with the questions about where these riots took place, whether at the same area where Mr. Porosh was. And Your Honor, in the doctor notes, regarding the doctor notes, our main argument is the immigration judge seems to not have a problem. Immigration judge stated they may corroborate, however, stated based on his opinion they should have included more. These notes, Your Honor, it's they only address the nature of the injuries and the type of treatment Mr. Porosh has received at that time.
Thank you, counsel. Case is taken under advisement, and the court will be in recess.